The judge listened for over an hour, then calmly explained why the landlord's own actions destroyed her case.
6 and 27. 6 and 27.
I'm in court all morning on the 6th, and then in the afternoon, I have court again from 1:30 to 3 over at
On the 6th.
on the 6th.
No, actually, I'm here on the 20th, I think.
What was the other date, Your Honor? 13th?
No, I don't have the 13th. I have the 6th and the 20th of January. Yeah. I know.
Does the 20th work for you?
I am scheduled for trial on the 20th, Judge, and it's going to go. So.
27th? Do I have, isn't that my trial week?
It's only civil trials scheduled for that day.
Okay. All right. I can also do the 27th if that.
Does that work for you? That fits my
That'll
schedule
work.
as well.
During this matter to January 27th, 2026, 9 a.m.
Thank you, Your Honor.
All right, thank you. And to both of you, if I don't see you, have a happy holiday.
Happy holidays to you as well.
Riverside Apartments versus DeShera McKinney.
James Fink for the plaintiff.
Good morning, Your Honor.
Good morning. Your name?
Shara McKinney.
All right.
Your Honor,
Yes,
this is a conference that should be held off the record.
it is. And so why don't we put both of them into the jury room? We'll put both of them there. Okay. You don't have any, this is the only one you have, Mr. Fink?
Yes, sir, I think so.
Okay, great. So if we can put them back there, then.
Mr. John, Mr. Simon is also covering that.
Merry Christmas.
Merry Christmas.
No, that's Mr. Moore. Or we don't know who's for January.
Okay, so we're waiting on January.
Yes. This is all Mr. Jarbo.
Got it. He's not here yet.
He is here. He is stepped out into the hall to speak with Ms. Anderson.
Okay, so Anderson and Lyman are both here.
Yes.
Okay.
Yeah.
And so we're just waiting on January.
Yes.
Okay, so. Well, I'm sure counsel he'll show up. He showed up at some point on one of my dockets and.
I hope so, Your Honor.
No, you don't. He didn't mean that. He was talking about your buddy. No, I'm just saying, man.
All rise. May be seated.
Oh, you can press it.
The courtroom grew quiet as the judge began breaking everything down. Not opinions, not emotions, just facts. Every inspection excuse, every unexpected visit, every change of story was carefully pulled apart. The judge explained how repeated attempts to check the property crossed a line, turning concern into interference. What sounded harmless at first slowly revealed a pattern the landlord never thought would matter. And when the judge finally explained his conclusion, it became clear this wasn't about unpaid rent anymore. It was about control, credibility, and boundaries that were repeatedly ignored.
Be seated. Court recalls the case of Riverside Apartments versus McKinney.
James Fink for the plaintiff.
Your name?
Shara McKinney.
We have had an opportunity to discuss the matter in chambers. And plaintiff has submitted an order denying the motion to set aside the default. Have you had an opportunity to read it?
She has not.
She has not. Okay. Basically, the terms of it are, and I'm going to give you an opportunity to look at the order. That what came out of the discussion is that I'm going to deny your motion, right? That the eviction order, which they've already submitted to the court on or about, shall be issued and ordered immediately, and I will sign off on that. And that the escrow of $1,147 that's held by the court will be released to the plaintiff immediately. And that you shall pay $2,000 in rent on or before December 22nd, 2025. Correct? You'll comply with all terms and conditions of the lease and shall not cause any disturbances or harass other residents of the building. The order of eviction shall not be executed before December 23rd. Right? But if you pay the $2,000 on or before the 22nd, complies with your lease, not cause any other disturbances or any other harassment of other tenants, the order of eviction shall not be executed on or before January 2nd, 2026. And I'm just going to make that change there.
Did I say honor before there? Your
You
Honor?
said shall not be executed before January 2nd, 2026. I had to change the 5 to a 6. If you don't comply with the order, plaintiff shall initiate an order of eviction by filing an affidavit of noncompliance with the court and sending copies to yourself and also to J.F. Morton Associates, who would conduct the eviction. You understand that, ma'am?
Yes, Your Honor.
All right. And neither party is waiving any claims to the lease under the Landlord-Tenant Relationship Act. Before I sign off on this, I'm going to have them give that to you so that you can take a look at that and make sure that's correct. And if you need time, I'll pass it real quick. I've got another case at least that I can call. I did.
Yes.
All right.
Give me that $5.
Hey, Ms. McKinney, you have any questions about it? Any misunderstanding?
I do not, Your Honor.
All right. And while it may not be the best for you, you think this is going to work out for you?
Thank you.
All right.
Could we get copies today, Your Honor?
Yes, you can. And I have signed it. Ms. McKinney, good luck to you.
Thank you, and I hope you have a happy holiday.
You do the same.
Thank you.
We have a hand make copies of it.
That's sometimes.
Yeah. All right. Did you want a copy also?
Sure.
All right. It'll take a few minutes, but we'll get it out to you. Just have a seat and we'll get it. Pleasant Lake Apartments versus Christopher Denowak.
Good morning, Judge David Morris for plaintiff.
Denowak, they are not here, counsel. Like a default?
I would like a default, Your Honor. Before requesting a default, I want to inform the court that there is a second pending case, and that was filed by plaintiff, so I don't mean to cast aspersions. And so I believe that to be the scheduling error because he has been participating. I wanted to bring that to the court's attention.
So plaintiff filed another case.
Correct, Your Honor. Separate and independent termination of tenancy based on the actions that have come about. That is scheduled for a second hearing on Friday. And I think that's just on the forefront of his mind is that hearing. And I think that pushed this out of his mind. And so I think he's worried about Friday.
Got it. Okay.
So if Your Honor would like to push this to Friday and deal
I
with.
really wouldn't, but I will.
I think that it will come out on Friday.
Yeah, and thank you for saying that, counsel, because then if I issue a default, what's going to end up happening is it's going to be set aside because he's going to say he had this other.
Correct.
All right, I will put this over there, although we're on Tuesday. I will put this over to Friday, the
Oh, no, 12.
so I'll adjourn this to this Friday. Well, 2025 at, do we know what time that is?
Yes, Judge. Two PM.
2 p.m. All right. So I'll set it at, that's a 12 at 2 p.m.
Thank you.
Thank you, sir. And Chirac versus Ford.
Good morning, Edward Mall, MAHL, P27115 for Mr. Sherrod.
All right, and this is the defendant's objections to garnish.
That's correct.
And is defendant here?
Apparently not.
Ford. The only indication on her motion is that the judgment's been paid, and you're representing the court that it's not been paid. Is that correct, counsel?
That's not, yes, that is, his statement is wrong, and we show a balance of $1,062.57. We show total payments of $701.24. So I'm sure he's not taking into account interest and costs.
Got it. All right. Yeah, should be objection. The objections to the garnishment are denied.
Thank you.
Calls the case of Anderson versus Lyman. Both matters being called.
Apologize for that interruption.
Not a problem. State your appearance, please.
Good morning, Edward Mall, MAHL, P27115, attorney for the plaintiff.
All right, where are we on these cases?
Good morning, Judge. My furnace had went out this morning. Not only did my furnace go out, Lori showed up to my house last month and had some guy walk around the back. But when he saw the camera, he ended up leaving.
What?
When the guy she had come to the house saw the camera, he ended up leaving. And she's still sending falsified information about the case to the water
To who?
department.
So somebody last week showed up to your house?
No, that's a video of him walking around the house.
Did you send somebody to the premises?
No, I certainly did not.
She was in the car. You can see
And
it in the
She
video.
was what?
She was in the car. You can see it in the video.
And Miss Anderson, you're indicating you didn't send anybody? So she had a video of that would,
I didn't send anybody to the house.
were you at the house? Were you in a car near the house?
And about a month and a half ago, I think I drove by one time. I didn't drive to the house. I think I just.
Was the car sitting there, ma'am?
Yeah, the car was sitting out front.
No.
They pulled up a little bit.
out front of
the
the
house. They tried to get out the view of the camera. And then he proceeded to look at the camera. And then he walked around the house and then he seen the camera and then he went back to the car and they pulled up. So he didn't finish walking around the house because he seen the camera.
you have that video
Yes, it's in my camera roll.
on your phone?
Yes.
Did you bring your phone in?
Yes.
Okay. Can you send it to the court if I gave you an email?
Yes.
You know how to do that? And also, you might need to send a copy to them. All right. These are all non-payment of rent cases, both of these.
There's a lot of issues, but we're slimming it down to non-payment of rent this morning.
Well, from plaintiff's position, what is plaintiff's claim in, I guess, either one of these cases?
Well, at this point, we are concentrating on rent. There's been only, how many months, 2 months paid? Only 9. That gives her credit for the escrow that's with the court of 6,600. 2 payments of escrow have been made only.
She's claiming over 21,000, Owen?
Yeah, she figures 22,499.39 is the balance. When I say she, I mean Miss Anderson.
And how much did you say?
66.
Servants. Let's take a look.
Yeah, I know that. I know that. I know that.
So what months is she claiming rent for?
All the months after, well, she has not paid anything since the first 2 months, May and June. She owes the rent from
So
July.
you're claiming for July?
Yes. August, September, October, November, and December. Not, yes. Okay, don't. Into the court.
You paid
I know
what?
that. We know that.
Paid those months.
Where?
Talking about July and all that, I paid that.
Yeah, July and August have been paid. They're escrow. They're in escrow now. September, October, November, and December.
Just citing counsel. So you're looking at 6 months, basically, right?
Yes, 6 months have not been paid to us. 2 months have been paid into the court. So this 4 months owed.
3,300. So, Ms. Lyman, I'm a bit confused because when we appeared here before, you had indicated that you were going to pay the rent into court escrow, and I don't have anything. I only have 2 months in escrow. How much did you pay in escrow this morning?
I paid that $22.70 that I said I was going to pay.
$22.70.
Yes.
What's this? That's still, but that's not, your monthly rent is 33.
Yes. Remember when I told you how I broke it down for the prorated amount? And that's what I came out to when we were here last time.
Okay, but if that paid, so here's my question. If I have in escrow July, we'll just call it July and August because those are the latest ones.
And I paid September this morning.
Okay. And then if that's, well, that's the 22. 70.
Mhm.
Yes, all right. So without going into even at this point, the difference between the two.
I'm only 2 months behind.
Okay,
Well-
but where is the 2 months?
But I don't have it right now. I was planning on paying at the end of the month.
I don't see how the 2270 pays at September either. And she's prorated it, but prorated, what does it mean? It's prorated. The entire amount is owed.
I didn't get it already.
I understand that, Council. What did I just say? So you don't have October, November, or December at this point.
The rest I was planning to pay at the end of this month.
What do you mean?
Like to pay the rest off at the end of this month.
So basically 9,900.
No, it should only been about 7,000.
Why would it be 7,000? Your monthly rent is 3,300.
Yes, only these couple months. I thought it should have been 7,650. I thought that was all.
Mm-mm.
You know, we've got a
There's
copy of,
6 months that's owed. Okay, I have 2 months in escrow. Right? So now I'm dealing with basically 4 months. You paid 2270. Again, I'm not going to get into necessarily why you got to that figure. I'll deal with that. I know what I have. But then when I look at October, November, and December, I have nothing.
Yes, because I didn't pay October, November, and then we're just getting to December.
Well, okay. So you're the two at this point, though, there's 9,900 that's owed at a minimum into court escrow. Right? What you say?
I suppose so, yes. Because I'm confused because I paid her May and I paid June when we first started.
The only thing I'm looking at right now is July through December. I'm looking at those 6 months. And if I'm looking at those 6 months, I have 2 and a partial.
Partial is in September.
Yeah. The 2270 that you paid today, basically a partial for September. Follow me?
Yes, I get what she's saying. I thought when I had mentioned the overpaid amount that I paid in June and the extra $300 and how much it would have been 533 to be prorated. That's how I came up with that 2267. Because I only owe 3 months of rent, including December.
I don't know where this proration you have is coming from, where you're taking monies off for September.
Because in May, I didn't get prorated at all in May.
Pardon?
I didn't get prorated at all in May
When you moved in.
Yes,
You moved in on what day?
on the 5th.
But your lease started what day?
It's got,
Which you started on.
On the 5th. And runs through what?
The 5th of next September. I don't remember the date.
I have a copy of the lease, Your Honor. It starts May 5, 2025. It ends May 4, 2027
May 4th.
of 2027. I have a copy of the, you have got it, okay.
So you follow that, ma'am?
Yes.
So there would not be a proration
How come?
because you would have 4 days in essence at the end of your lease